Hey guys, this is John Watts. Welcome back to our video here. We are going to talk about a case under the FDCPA Fair Debt Collection Practices Act. This is the McCray case out of Florida, Middle District, Florida, Tampa Division. It's from February of this year. Here's the gist of this case. Does a collection letter from a debt collector that tells you your rights under Section 1692G, which that's the one that says you've got 30 days to dispute this, you can request validation, request the identity of the creditor. Is that overshadowed or contradicted by other language in the collection letter? Because if it is, then that violates Section 1692G. And so we have this lawsuit that was brought. There are actually two sections that the plaintiff said were violated, 1692G and then 1692E. E is the one that says don't misrepresent, don't be deceitful. And we have something that we haven't talked about before called a judgment on the pleadings. And we'll get into what that is a little bit later. But basically it says you don't need any evidence, you don't need any facts, because just looking at the complaint that the plaintiff filed, it's obvious that they lose. Okay. And so the court said the defendant said to the court, we want you to rule that we did not violate 1692G or E. And the court said, well, I agree with you, collection law firm, debt collector defendant, on 1692E10 that there was not a misrepresentation of the period of time to dispute. But on the 1692G, which is the overshadowing claim, and one under E10, sort of this, you created this false sense of urgency deceptively. The court said, no, I'm not going to grant that. And this is really ironic. The court said to the defendant, I tell you what, show me why I shouldn't grant judgment on the pleadings against you in favor of the plaintiff. And so that's what the court's looking at here. So here's the letter. And this is one of those cases where there's really no dispute about what's going on. It's just a letter, and there's no telephone calls, there's no factual dispute. Everybody agrees what the letter says. So I want you to notice a few things here about this letter. So, authorized to use any means at our disposal within the limits of the law necessary to collect. And then, in order to resolve this matter immediately, please contact this office, and it's a telephone call. Not saying write to us, they're saying call us. And then if we don't receive payment promptly, we'll be forced to take additional action to recover. And then this is standard in any debt collection communications attempt to collect debt. Any information obtained be used for that purpose. Sometimes that's called the mini Miranda, like the miniature Miranda rights. You have the right to remain silent. Anything you say can will be used against you. That's what we're talking about here. But the actual 1692G A language is this. So you've got 30 days, you can dispute the validity, and if you don't do that, we'll assume the debt's valid. If you do notify this office in writing within 30 days, we'll obtain verification or a copy of the judgment. If you request in writing, we'll give you the name of the creditor. And then this is a very lawyerly sounding thing. I don't know why people do this, but some lawyers think this is very clever. Please govern yourself accordingly. So the plaintiff saying, look, that stuff about immediate payment and threat of additional action if payment was not promptly made overshadowed the right. All right, so here's the test on a judgment on the pleadings, and this is Federal Rule Civil Procedure 12C. And it's when there's no material facts in dispute. In other words, we're just looking at the pleadings, the answer and the complaint, the lawsuit. And the judgment can be rendered by considering the substance of the pleadings and any judicially noticed facts. That just means sometimes a judge can be aware or take judicial notice of things like maybe that a certain day is a holiday. Okay, they can just say, we know that because we're the court. All right, so where the plaintiff moves for judgment, the fact allegations they answer are taken to be true, but those of the complaint are taken as true only where and to the extent they do not conflict with those of the answer. So two things to unpack here. One, remember the plaintiff did not actually move for this. The defendant did, and the court said, You make a good point. We should have judgment on the pleadings, but I think it should be against you and in favor of the plaintiff. And second, what we're basically saying is where everybody agrees on the facts, that's what we're going to take. And whatever the defendant says in their answer about the facts, we're going to take that as true. Here, it's pretty easy because it's just that letter. This letter that we looked at up here. There's no dispute about what the letter says. All right, so here are the 3 requirements that this judge says you must meet in order to have an FDCPA claim. And remember, some courts break these into 4 elements. This judge says 3. So it's consumer debt, number 2, debt collector, number 3, the defendant, debt collector, violated the law. All right, so let's see what is not in dispute. No dispute the plaintiff was the object of collection activity arising from consumer debt, and there's no dispute the defendant's a debt collector. So the sole issue is, in that letter, was the FDCPA violated? So what are the requirements? This is at 15 USCA section 1692GA. So this is called, normally people call this the validation notice. So it tells you you've got 30 days, let me just highlight this, to dispute the validity of the debt. If you do it in writing, they'll verify the debt, give you the name and address of the creditor. And remember, we have talked about this in other videos. When you send a proper validation notice, dispute letter, within that 30-day period, the debt collector basically has 3 choices. Do nothing, so they don't respond to you, but they don't collect. Or they respond to you properly, or they get rid of the debt. Those are their only choices. Okay? And so here the parties say, you know what? The letter told us everything we're supposed to know in 1692GA. But here's the dispute. 1692G subsection B says, even if you get Part A right, if the other language in that validation notice overshadows or is inconsistent or contradicts the right to dispute, the right to request the original creditor, then it violates the law. So how do we evaluate these? Under what's called the least sophisticated consumer standard. So we'll look at the actual language, but basically this is saying we're not talking about if you're a law school professor, okay? That's not the standard here. Like, would a law school professor be confused by this? Would a consumer protection lawyer that sues debt collectors all the time, would he or she be confused? That's not the test. The test is somebody who doesn't have any knowledge about the FDCPA or about the law. Would they be confused about this? So here we go. Least sophisticated consumer takes into account consumer protection laws are not made for the protection of experts, but for the public. And then this is saying the vast multitude, which includes the ignorant, the unthinking, and the credulous. But here's the kind of the thing to counterbalance that. There's an objective component. And while we want to protect naive consumers, we also don't want bizarre or idiosyncratic, kind of a word we don't often use, but just sort of bizarre interpretations of collection notices by preserving a quotient of reasonableness. And so we've got the court saying here, would the least sophisticated consumer, so we're not actually looking at the plaintiff himself or herself, but we're saying this kind of hypothetical least sophisticated consumer, would they be confused? Would they think that there's an inconsistency here in the collection letter? And if so, then the law's been violated. And this is something that the judge can decide. In other words, he does not have to let a jury decide. The judge does not have to say, you know what, we'll have a jury make that determination. She can make that determination if we're just looking at the letter itself. Okay? And remember, that's all we're talking about in this case is that letter. So here's a starting point. And you'll see a little bit later, there's almost a contradiction with what we're about to read, but it's really not. It's just kind of like coming at it from 2 different angles here. So an unqualified demand, consumer pay a debt prior to the expiration of the 30-day validation period, overshadows and is inconsistent with the statutory rights. That's your starting point. So you get that letter that says you've got all these rights to exercise within 30 days. But then if there's a demand that you pay the debt before 30 days, you violated the law. Okay? And here's another part where such demands combined with threats of immediate adverse action. And now we're going to see some kind of qualifying language, okay? But that's just your starting point. And the court in Florida, which is in the 11th Circuit, 11th Circuit is Alabama, Georgia, Florida. It says the 11th Circuit, get this to highlight, hasn't addressed this, but 3 other circuits have. So circuit courts are the appellate courts. So we have the district court judge. That's different than like a small claims judge in state court. District court's what we call the trial judge in federal court. And then you have the appellate court, or the court of appeals. And so here's the first case, this Savino. So here's the validation letter. You've got this overdue balance and immediate payment, or a valid reason for your failure to make a payment. And then it had those proper disclosures on the back. And the district court, the trial judge, said, look, I rule in favor of the plaintiff because you violated the FDCPA, demanding immediate payment contradicted the language of the 30-day, and thus it's misleading. So then that gets appealed to the Second Circuit. And that Second Circuit agreed. And they said, requests for immediate payment did not standing alone violate the FDCPA. Here's where I say it's a little bit contradictory to what we looked at up here. Unqualified demand, pay a debt prior, overshadows and is inconsistent. Well, and let me read this sort of parenthetical part. Without any language explaining the demand does not trump the right to within 30 days. So they're really saying the same thing, is that you can demand payment within 30 days, but you better tell the consumer you still have the right, even though I told you to pay within 30 days or take some action within 30 days, you still have the right to request validation of this debt. And so we see here, consists of decision to ask for immediate payment without also explaining its demand did not override the consumer's rights. And then it says, let's give you some examples. If you had used one of these 2 paragraphs, then you would not have violated the law. So let's look at this first one, see if it makes sense. Although we've requested you make immediate payment or a valid reason for non-payment, you still have the right to make a written request within 30 days of your receipt of this notice for more information. Your rights are described. Okay, that would be fine. So even though they're demanding immediate payment, they're saying, but you still have the right to take the full 30 days. Here's a second example the court came up with. Our demand for immediate payment does not eliminate your right to dispute this debt within 30 days. If you choose to do so, we're required by law to cease our collection efforts until we have mailed that information to you. And you can look on the backside to get those rights. Okay, so that would effectively inform a consumer as to his or her rights under the FDCPA without imposing an undue burden on the collector's legitimate efforts to get paid. So the court's saying, we're not in favor of the consumer or the debt collector. This is fair to both sides because debt collector, you can still demand the payment, but consumer, you still have your full rights and you're not confused by this. Now, how about the next case? So the Bartlett case. Let's look and see what the debt collector did here. And it says, if you wish to resolve this before legal actions commence, you must do one of 2 things, notice the time period, within 1 week. Within 1 week of the date of this letter. Well, what are those 2 things? You can pay or get in touch with the creditor and make arrangements. If you do neither, it'll be assumed that legal action is necessary. Well, wait a minute. I thought I had 30 days to dispute, and now you're telling me I have 1 week. And the trial court, the district court, said, there's nothing confusing about that, and ruled in favor of the defendant. And then the Seventh Circuit, which is Illinois and some other places, reversed that. And we have Judge Posner, who I don't always agree with his outcome, but he's a very interesting writer. And I'll try to find some other opinions of his. I think you'll like this. He says, well, on the one hand, it says you're going to get sued if you don't pay within a week. But then on the other hand, it says you got 30 days. So that leaves up in the air what happens if you're sued on day 8, but you disputed on day 10. And Judge Posner says he might wonder what good it would do to him to dispute the debt if he can't hold off a lawsuit. And then I love this right here. You don't see many opinions like this, but this is just classic Judge Posner. The net effect of the juxtaposition, the combining of the 1 week and 30-day crucial periods, is to turn the required disclosure into legal gibberish. I love that. Legal gibberish. That's as bad as an outright contradiction. And then this court said, well, we'll give you a safe harbor. Okay, the other court called it transitional language. Safe harbor in the law, it kind of invokes the image of you're on a boat and it's really rough storms. You sail into the safe harbor and there you're protected. So it says, if you would do this, you would be safe. And so let's highlight this. So you could threaten legal action if the payment is not received, so long as the threat or demand is accompanied by language explaining that if within the 30-day period the consumer disputes or requests verification, requests name and address of the original creditor, the law requires the creditor to suspend its collection efforts, whether through litigation or otherwise. And because that didn't happen, the Seventh Circuit said you violated the law. So here's the last one, Miller. And you have to appreciate this is in all caps and got dramatic language here. Demand for immediate full payment of your debt. You're seriously past due, immediate action. You've had ample time. If there's valid reason, phone us today. If not, pay us now. So look at this language. Now, today, immediate. And then it does give the disclosure under 1692GA. And the district court said, no, there's nothing wrong with that. It doesn't overshadow it. But the Fourth Circuit reversed. And it said, well, let's kind of follow the demands and see if the consumer would end up losing his or her rights under the law. So we start off with 1692G. Validation will be sent. Collection activities will cease only when the dispute is in writing. So if you exercise your statutory rights by making the call demanded in the validation notice, then the debt collector would be under no obligation to comply. Because remember, they said, call us. They didn't say write us. Well, if you do that, so you think, okay, I'm exercising my rights to dispute within 30 days, request validation. Well, if you called, they would have no obligation to do anything. So no obligation to comply with Section 1692G's directives to verify the debt, cease collection activities. Language on the front emphatically instructs consumer to dispute the debt by telephone instead of actually the statutory requirements. And then here's some more. The emphasis on immediate action also stands in contradiction to the FDCPA, which gives the consumers 30 days to decide whether or not to request validation. So a consumer who received the validation notice could easily be confused between the commands to respond immediately, now, today, and the 30-day response time. So which is it? And the court concludes with plainly undercuts, overshadows the message of the validation notice, and if we were to uphold this letter, then it really guts the statute of its disclosures under 1692G. And then this court, so we're back now to the court in Tampa, says district courts have looked at this, and it's going to look at these cases here. So in this particular case, summary judgment was in the plaintiff's favor. Well, why is that? Because it says, the judge here says, it overshadowed the plaintiff's right to dispute the debt within 30 days because validation notice stated the debt was subject to immediate collection efforts and demanded the plaintiff contact defendant as soon as possible and suggested defendant would immediately report the debt to the appropriate credit reporting agencies. Well, that overshadows that 30-day period. So here's another case. And this judge denied a motion to dismiss the plaintiff's overshadowing claim. So what's going on here? Demanding payment of debt within the 30-day period without explaining that the demand did not override the rights under, and it says 1692 G to seek validation of the debt. And that may be a typo with Google Scholar. Sometimes you'll see, numbers get sort of transposed or reversed. But anyway, that could confuse an unsophisticated consumer and believe that the right to request validation is outweighed by the demand for immediate payment. And then the Creighton case, summary judgment in favor of the plaintiff. And here's the language. Be paid in full upon receipt of the notice. Contradicted the declaration that you had 30 days. And then in the Vaughn case, court says that it violated 1692G as a matter of law because validation notice demanded immediate action, either payment or phone call. So that's important. It's not just payment, but here payment or a phone call, and it threatened to report to the credit bureau if action wasn't taken. Well, how soon does action have to be taken? Immediately, according to this. And so, let me get this highlighted. Demand for immediate payment coupled with its threat to report to the credit bureau overshadowed or contradicted the statutory notice provisions so as to render the validation notice deceptive and misleading. And then here we have kind of the conclusion from this judge. The only reasonable inference that may be drawn from the characteristics of unsophisticated consumers and the coercive effect of the explicit threat is that a substantial majority of unsophisticated consumers would interpret the demand for immediate payment as contradicting, overshadowing, or even nullifying, invalidating the debt validation notice printed on its reverse side. And so now we're back to the judge in Tampa, her analysis here. Court finds that the letter that we looked at earlier violates 1692GB because it's immediately contacting at a phone number and authorized to use any means at its disposal, collect the full balance of the debt, additional action if defendant not receive payment promptly. And looking at those three circuit court opinions, particularly the first two, remember they talked about safe harbor or transitional language. It says, the judge here says, there's no safe harbor transitional language explaining that notwithstanding the demand, you still have the right to make a written request within 30 days. There's no such language like that. And then here's kind of the final nail in the coffin here. The demand letter was sent on law firm letterhead with an attorney's signature. And this is probably Judge Posner. I don't remember if it is, but it sounds like him. The Seventh Circuit case, we're going to read the quote. Debt collection letter on attorney's letterhead conveys authority. Unsophisticated consumer getting a letter from an attorney knows the price of poker has just gone up. Okay, so here we have unsophisticated consumer, and let me get this highlighted, would be unable to reconcile with any degree of success the inherent inconsistency. So you've got this demand written by a lawyer for immediate payment and legal action, but yet contradictory to that, they say, well, you got 30 days. So how's the consumer supposed to process that? And there's a general concept in the law that if, let's say, a debt collector writes a letter, well, that any ambiguity will be construed against that writer. So if you write something, you make it confusing, then you pay the price for that, not the person that is on the receiving end of that. And then this is an interesting argument, good argument by the lawyer for the consumer. If the plaintiff had attempted to exercise her statutory rights, so you've got the right to request validation, name and identity of the creditor, by calling the defendant at the bolded and underlined telephone number included in the letter, instead of submitting a written request, she may very well have waived her statutory rights, as the defendant would be under no obligation to comply with 1692 directives to verify the debt or disclose the original creditor and cease its collection efforts. And court says, therefore, I'm going to rule in favor of the plaintiff, the consumer here. And so grant in favor of that on section 1692G. And this is a little bit of kind of procedural stuff, but a judgment is not final unless all the claims against all the parties are 100% resolved. And if we don't have that situation, so not all claims against all parties are resolved, then to make a judgment final, which it needs to be final typically to appeal it, the court has to explain why it should be made final. And here the court says, I decline to direct the entry of final judgment on overshadowing claim as just reason for delay exists. And it's a little bit sort of interesting here, but this is why, this footnote 2. And it's going back to another case here. Judge Cord denied the motion of summary judgment because plaintiff advanced a single claim alleging defendant's letter violated multiple provisions of the FDCPA. And here it says plaintiff pled, get that to highlight, pled solely her overshadowing claim in count 1, as such can fully resolve count 1. So let me explain this. So you can bring a claim, and we typically in lawsuits will have count 1, count 2, count 3. So let's use a car wreck, for example. We would say count 1 is negligence. So that's being careless. Count 2 is recklessness or wantonness. That's being where you know what you're doing. You may not intend to hurt the other person, but you know there's a high degree of likelihood. So you're speeding while texting and driving, or you're drunk. That's reckless. Well, number 3 might be negligent entrustment. In other words, we say the company knew their driver was incompetent to drive, but they gave him the car anyway. Well, if you combine all those into one, then it makes it harder for the court to sort this out. And here the judge is saying that this was pled properly. And the court will not direct entry of final judgment as just reasons for delay exist. Here's the language, Federal Rule Civil Procedure 54B. If we don't resolve everything, then the court may direct entry of final judgment as to one or more, but fewer than all claims or parties, only if the court expressly determines there's no just reason for delay. So judge here, she's saying there is reason for delay because the false sense of urgency claim under E10 remains pending and awaiting adjudication. So we don't really like cases being split into parts. Like, okay, this is final and you go appeal this part, but we're still going to be litigating this other part. Judges prefer to keep it all together. So that's what's going on here. So the takeaway from this case is you get a collection letter and it has a validation notice in it and it has a demand for immediate payment. Then, at least according to this court, and you saw the cases that she cited in here, I think they're very well reasoned, that's going to violate 1692G unless there's language in that letter that says, by the way, even though we've demanded immediate payment, we've demanded you do this before 30 days, you still have your right to fully take the 30 days, fully dispute, fully request validation. So it's got to have that disclaimer language. Now, if you have a letter like that and you want me to look at, I'm happy to do that. You can send that to me, John at wattsherring, WATTSHERRING.com. And John is JOHN. So John at wattsherring.com. Just shoot me a copy of that letter. I'll be glad to give you my thoughts on it, whether or not I think that violates this overshadowing provision of the law. These things go in cycles, as most violations of the FDCPA do. A lot of times we won't see any of these. Everybody kind of has their letters clean. They're doing them the right way. But there's always this temptation for the collectors to push that envelope and make it a little more aggressive and get you to pay right now. And they say, I don't want to put that disclaimer language or that transitional or safe harbor language. I just want the consumer to pay right now. And then they'll start violating the law. And typically, this is not a letter drafted just to you. This is a letter that they've sent to hundreds or thousands of people. And that's why typically a class action comes into play to represent everybody against the debt collector. So I hope you enjoyed this. I'll put a link to this actual opinion on Google Scholar so you can go look at it yourself. And I appreciate you watching this video, and I will catch you in the next one. Thanks, guys. Bye.